Landlord-tenant law is complex and varies from state to state. Even though the law is complicated, there are several ways to avoid getting sued by tenants. If you own a rental property, you need to know what you can and cannot do in order to avoid getting sued. In this video, we'll go over the most common reasons why landlords get sued by their residents. A lease agreement is a binding contract between the landlord and the tenant. As a landlord, this lease will be the first place you turn if there are any disputes, disagreements, or conflicts during the lease period. So you need to ensure that it is legal and binding. At times, landlords like to make the mistake of writing into their lease agreements certain provisions that are void or unenforceable. Some examples would be a clause requiring tenants to pay for all damages to a rental unit, regardless of whether or not the damage is normal wear and tear, or a clause prohibiting all animals, including service animals. These clauses will not hold up in the court, and you'll also run the risk of the judge throwing out the entire lease agreement. For starters, make sure you're using a lease that is valid and enforceable in Arizona. It should reference laws and requirements that are specific to this state. A lot of landlords make the mistake of downloading a lease template or using a sample that isn't specific. You want to make sure your lease will hold up in Arizona courtrooms if necessary. Our previous blog of what to include in a proper Phoenix rental agreement lists down several important elements that are absolutely a must to be included in your lease. Also, if you're not working with a professional Phoenix property management company, we recommend that you contact an attorney before you draft and sign any lease. Arizona law is pretty straightforward when it comes to security deposits. There are limits to how much you can collect, as well as timelines for returning the deposit at the end of each tenancy. Your tenant can file a lawsuit against you if you have not refunded the security deposit or are wrongfully withholding a portion of it. Legally, landlords are permitted to charge the deposit for damage as well as any cleaning expenses, unpaid rent, or overdue utilities. They're not allowed to charge for wear and tear. As a Phoenix landlord, you should understand the distinction between damage and normal wear and tear and make sure your lease agreement states exactly how you expect to find the property returned to you after the tenancy. Note that under Arizona law, a landlord is given 14 business days to return the security deposit with an accounting of what was withheld. There are currently 7 protected classes, and rather than listing what those are, we'll let you know that almost everyone who walks in and ultimately becomes a tenant can fall into one of those categories. For instance, getting a broken appliance repaired quickly for one tenant while making another tenant wait could be perceived as a fair housing issue. It is difficult to stress how important it is to follow fair housing laws. Non-compliance with these laws can lead to a lawsuit that eats up the equity in your property. If a fair housing complaint is filed, HUD reaches out to you to determine if the complaint is valid. A civil penalty can be $6,000 to $100,000. You may also be charged for punitive and non-economic damages. The best way to protect yourself and your investment, both financially and legally, is to be complying with fair housing laws. Treat everybody equally and consistently. During the application, have a fair and consistent process. Later during the residency, you must continue to treat everyone equally. When it comes to maintenance, you don't want to favor one tenant over the other. The Landlord-Tenant Act includes many rules about tenants and landlord rights, including the right to quiet enjoyment. To put it simply, a tenant has the right to be left alone. The tenant's right to a peaceful and undisturbed enjoyment of the property prevents a landlord from entering the property without good cause. When entering a property, you should keep the following in mind. Notify your tenants in writing when you're coming over. The notice must be sent at least 48 hours in advance, with allowances for mailing time if sending via mail. You could also gain permission verbally as well. Property owners should be considerate about making appointment times and avoid changing appointment times at the last minute. When a landlord is in a unit, they should avoid touching anything. The tenant has certain rights to the property through their lease, so landlords should treat them with respect. You should enter the unit with caution if there are any unaccompanied minors. Property owners should never just show up at the property to check on things or overuse their access rights. Landlords are required to disclose any known, existing, or previous lead paint hazards, mold issue at the property. Moreover, a tenant may file a lawsuit against you if you do not keep the property in a safe, habitable state. For example, your AC is not working in the summer, the only toilet won't flush, or you don't have any running water. Don't wait for minor and affordable problems to turn into larger, more expensive catastrophes. When your residents report maintenance issues or request a repair, take care of it right away. A leak that's been ignored for weeks or months is going to turn into a plumbing disaster and may result in rot or mold as well. Deferred and unreported maintenance can cause a lot of damage to your property and relationship with your residents, so take care of things promptly and thoroughly. Preventative maintenance can also protect you against property damage. Schedule annual inspections for your air conditioner, water heater, and roof. A dedicated Phoenix property management company will be able to help you navigate the intricacies of the industry, keep a positive relationship with your residents, and help you steer clear of avoidable consequences. Call us today at Service Star Realty.